Hello, I'm Andrew Thomas. I am here to give some analysis of a bill that was presented in the Montana State Legislature in 2025, SB 146. SB 146 deals with issues of property rights and the ability to appeal government regulation. So this is a analysis as well as critique of SB 146 that should be considered in any revisions of the policy or in moving forward to refine the policy to make it more effective. If you have any questions or comments, feel free to reach me at my email address, businesslawpolicyanalysis@gmail.com. All right, so SB 146 proposes elevating the concept of property rights. So that is a property owner's interest in using their property, so the right to utilize their property, to the highest constitutional standard, which is strict scrutiny. The standards in SB 146, so if you look at the bill text, apply to all forms of land use regulation and to some extent apply to other forms of property as well. So SB 146 has a very high standard for considering property rights and the effects of economic regulation on those rights, as well as being very broad in terms of what type of property it applies to, both real property and likely tangible property as well. So a couple of passages from the bill text, which I encourage you to look up the entire text and read it carefully, is the property use restriction is demonstrably necessary and narrowly tailored to fulfill a compelling governmental interest in public health or safety. So the standard right here is that for a government regulation to have effect on a property and not be overridden by the property owner's interests in the property, the governmental interest must be narrowly tailored to fulfill a compelling governmental interest in public health and safety. The property use restriction is the least restrictive means to achieve the stated purpose of the restriction. So there are alternatives that exist, and that out of the menu of policy options that the government has available to it, the government is mandated to use the least restrictive regulation when it comes to regulating property. Alternative mechanisms could not achieve the stated interests of a governmental entity. So this reiterates the second part of the text, which is that there are no other alternatives. This is the least restrictive regulation that is applied to the property. Additionally, the bill does mention private property as having the same meaning as real property. However, if you read the bill, there is some ambiguity as to what specific type of property it applies to. So that is the summary of 146. Now, the problem with 146 is that there are a few dimensions of it. First, there is a misapplication of constitutional standards. So the Supreme Court has made a doctrine of policy review standards that vary depending upon the right that is infringed, who the regulation is applied to, and what the government interest is. This is known in constitutional law as levels of scrutiny. There are three levels of scrutiny. There is strict scrutiny, intermediate scrutiny, and rational basis. Generally speaking, economic regulation applies to rational basis. Strict scrutiny applies to protected classes. So just to fill you in on the details so that there is no ambiguity in understanding this concept, I'm going to go through the three levels of scrutiny. So strict scrutiny is intended to address issues of fundamental civil rights with regards to discriminating against groups of people that are parts of constitutionally or are members of constitutionally protected classes or that deal with fundamental rights. So if you are being discriminated against by virtue of policy based upon race, national origin, citizenship, religion, and so forth, and the policy is depriving you of a fundamental right, such as voting, employment, marriage, freedom of speech, this is strict scrutiny. The government under this test must prove a compelling interest. So it has to have a very, very good reason for doing what it's doing. And that the law is narrowly tailored. So implicitly, what this means is that there are not less restrictive alternatives available to the government, and that the government's policy is very strategic and very specific and does not bring in anyone other than the targeted group for regulation. Obviously, you can see the importance of strict scrutiny, because if you're discriminating against people, so for example, the very famous case of Korematsu v. United States, which dealt with the Japanese internment camps in World War II, dealt with issues of strict scrutiny, you want to ensure that the government has a very, very good reason for having these policies, because you're dealing with identity issues of people that cannot be easily changed. You're also dealing with people's fundamental rights that should be unambiguously protected. Same basic idea goes for the burdens of proof in civil versus criminal cases. If we're going to deprive somebody of their liberty, we want to ensure that there is beyond a reasonable doubt of certainty that the individuals are guilty, because you're dealing again with fundamental rights. Intermediate scrutiny deals with classes that are not considered as distinctive as those that fall under the strict scrutiny review. So gender, for example, age, and so forth. They're still important. You still do not want to discriminate against individuals based upon characteristics such as gender, age, but there's more flexibility in dealing with those standards. Also, regulation of, let's say, a loud political rally in an urban area. So that's Ward versus Rock against racism. There's more of a government interest, but it's still important. You're dealing with important rights, important groups of people. The standard for intermediate scrutiny is that it must be reasonably related to an important government interest. And again, the standard is a little bit lower, but it is intended to protect individuals. So another example of intermediate scrutiny is actuarial evaluations for state pension systems. Women live longer than men. Their benefits are calculated based upon the assumption that they will outlive men by X number of years, statistically ascertained. That goes into the actuarial computation of how much they have to pay into a pension system to keep the pension system solvent. There's a reasonable relation between intermediate scrutiny and the important government interest of keeping the pension system solvent. So the one that relates the most to SB146 is rational basis. To give you a little bit of an idea of how the rational basis doctrine developed, it arose under the premise that governments, especially modern governments, are going to have to regulate economies to some extent, and that they're going to have to try new and different things in terms of regulatory policy to limit, let's say, things like pollution, or to promote, let's say, economic development, or address some type of traffic congestion, or vague, broad, complex, somewhat unascertained economic issues. Therefore, the initial idea of rational basis was intended to give government enough flexibility so that it could experiment with policies to maintain, some amount of a regulatory state to be able to intervene and nudge the economy in a certain direction. Rational basis obviously became more important in the Industrial Revolution, the Progressive Era, and it definitely took off after the New Deal. So that's the logic of it. It's not necessarily a capricious bit of policy on the part of policymakers, and there is some defensible case for it. However, as we will see, it is definitely with its flaws that do invite some criticism. So rational basis applies to essentially anything that can be described as an economic regulation that's universally applicable to individuals. So it doesn't matter what the type of regulation is. It could be food safety, it could be land use, it could be banking policy, it could be air traffic control policy, so forth, any type of economic regulation. The standard of rational basis is that it must be rationally related to a legitimate government interest. And by rational relationship, what that means is that the government's rationale must be logically stated and it must correlate to some government goal. It does not insinuate that the rational articulation will, in fact, affect that outcome. So, for example, you could create a massive tax on junk food. And the logic is that by taxing junk food, you will promote public health by making junk food expensive. And if that doesn't end up becoming the case because everybody likes their Twinkies and Ho-Hos and Doritos, then even though there is no correlation between the junk food tax and increased individual health, so something that can be ascertained through statistical analysis or some other form of social science-based analysis, the law is still considered valid. So there is a lot written about rational basis. I would encourage you to go on Google Scholar. There's many law review articles, and there are many court cases dealing with rational basis. And the sticking point, though, moving from simply developing policy and enacting it into law is what happens when you have a bad policy under rational basis. So Justice John Paul Stevens reaffirmed the lenient nature of rational basis in a concurring opinion, the Supreme Court case. And he states, as I recall my esteemed former colleague, Thurgood Marshall, remarking on numerous occasions, the Constitution does not prohibit legislatures from enacting stupid laws. That is a rather frightening statement, but unfortunately it is legally accurate. Now, here is the issue. The Constitution does not prohibit legislatures from refining rational basis and creating a more logical standard of balancing the interests of individuals and the rights of individuals against the interests of the state and the interests of other people. In fact, it may be a very rational thing to do that and to create a framework for doing that. Additionally, having that standard does not necessarily mean that you need to change economic or property regulation to being strict or intermediate scrutiny. I will get more into that in the next couple of slides. So another feature of SB 146 that is highly problematic, and I understand the intention of the drafters of 146 were to make it broad and encompassing. However, it may have been useful to be a little more strategic and realistic in terms of introducing this new standard to the legislature, is that it is very broad, overly such, and it creates a number of conflicts that even a person who has a superficial knowledge of land use regulation can clearly see. So specifically, 146 does not target specific areas where reform is likely needed and where it will likely benefit property holders and not create conflict. Also, it invites unnecessary litigation of parties. It opens up a can of worms that invites litigation that questions the authority, for example, of urban or incorporated jurisdictions to be able to plan. As we can readily observe, urban areas, the urban form is heavily dictated by planning, by government action. We might not like what the governments do, but when you go to a city is a creation of individual decisions. And that balance of power between individuals' interests in doing things and, for example, the community or government's interest is very different than, let's say, what would happen if you live in a rural area of 1,000-acre farms or houses on 5, 10, 50, or 100-acre lots. So in terms of its overbreadth, one of the major issues is SB 146 applies to urban areas and citizen-zoned areas. Again, the urban area is largely defined by government policy, and to a great extent, the urban area's nature must be defined by the government in some way, which isn't to say that there shouldn't be flexibility, which isn't to say that there shouldn't be some more specific consideration or articulation of the interests of individuals against a community. But again, when you go to a city, it is planned and necessarily such. If you do not have planned cities, what you have is something that would be similar to a third world slum. And I would encourage you all to go on the internet and look at satellite images of what country or cities in developing countries look like. Also look at images of how people live there. It is definitely not something that most people in the modern world consider desirable. And most developing countries aim to at least add some order to development so that they can ensure public health and welfare and quality of life. Another shortfall of SB 146 is that citizens choose to live in areas with citizen-initiated zoning. So it's either citizen-initiated zoning or homeowners associations, which is just another variation on it based upon covenants written into the titles of property and or regulations enacted through citizen-initiated zoning. These are characteristics of neighborhoods, such as, for example, single-family housing, no short-term rentals, down to relatively minute things and some more stringent HOAs like not putting your trash can out on days when there isn't garbage pickup and so forth. Again, these are things that are aspects that represent a private contract of the people that live in those communities. And if you move to one of those communities, you have to be aware of their existence. Also, with citizen-initiated zoning, the basic legal standard for them is that the things that can be regulated by those private contracts are generally considered things that touch and concern the land. So you cannot, for example, dictate the clothing people wear through a covenant. You can't dictate the color of their house or the types of flowers that they grow in their gardens, so forth. And I fully understand that this gives rise to often petty disputes amongst people who are in HOAs. However, that is a feature of the HOA. Also, more broadly, when we look at a failure of SB 146, it takes somewhat of an extremist position in that it does not consider the interest of community members in their community. Although this interest is more nebulous, it is more expansive than a property owner's direct interest in their property, it is still an interest and still, at least with regards to citizen-initiated zoning, a property right. And it needs to be balanced or at least acknowledged against the more immediate rights of property owners. And if we look at the body of property law in Montana, and more broadly in common law dating back to the Middle Ages, there has been some articulation that the community has an interest, at least in some limited way, of regulating private property owners if it so dictates that it has that interest. Now, the standards might be low, such as preventing nuisances, which SB 146 does articulate. But when we look at modern communities, especially urban ones, or ones that have a higher density of buildings, there is obviously a balance between the character and nature of a community and an individual's interest in maintaining a certain character and nature. And rather than completely disregard that interest, there should be a more articulate balancing of those interests of the private property owner against community-based regulation. So just an example of how these interests play out, and this is pretty clear articulation of this issue, even though there's obviously variable interests of the community in somebody's property and the nature or a property owner's interest in the nature of their community, we can still see those things. So on one extreme, you might have someone who lives in a relatively unpopulated valley out in the Western US. They can see for 30 miles and they don't want to see little lights 10 miles away. This is a relatively minor thing. On another level, if you have someone who lives in a relatively dense single family neighborhood that by any metric is considered to be of an urban density, having a lot next to that individual's house bulldozed and having a parking garage or a 5-story apartment building built to take up the entire lot obviously affects that property owner's property rights and the nature of their community in a much more tangible way. So these photos here highlight this and highlight the need again to find a system that articulates the balance between property owners and the communities that they live in. So the image on the left is an image of what is known in property law as a property holdout. This is an individual who has a house, I believe, in Seattle, Washington. A shopping mall was being built around their single family house. They didn't want to move. They were an older, elderly person. And the other property owners in the neighborhood all sold out. This person refused to move. They were very attached to the house. So what ended up happening was they were walled in with concrete. Obviously, this property owner's interest in their property is very discernible, or in the contiguous property is very discernible. And from a planning and government policy perspective, one, we want to avoid these things. We want to acknowledge their interest in their community. And we want to find some balance that resolves this issue. Now, in this instance, it also highlights what happens when a majority of people in a community decide, all right, we no longer want to use the property in a certain way, and everyone else leaves. This person is left dealing with the consequences. So that's one example. The image on the right is the opposite instance. So here you have a very low density subdivision. The houses appear to be minimally on 1, if not 5-acre lots, give or take. This is outside of Bozeman. Obviously, low density development. The houses either use a community well, they likely all have septic. They're not reliant on public infrastructure other than power lines, telephone lines, and roads. Now, let's say that the property owner here with the field wants to build another subdivision that will be generous, dissects this lot into 2, let's say, 5-acre lots, and he wants to put houses on them. Now, the property owners in this low density subdivision they've maybe gotten used to this field. They like the view that's unhindered by new structures of the mountains. Their kids might sneak in there to play or whatever. They're kind of attached to it. You know, they represent the classic NIMBYs, and they want to fight to maintain the community character. Well, in this instance, adding even lower density housing to this area clearly isn't going to tangibly affect these individuals' lives too much. Therefore, the interest in the adjoining lot of the people that live in the low density subdivision is likely going to be a lot less than the interest of the individual who lives in this area that has been essentially paved over in the image on the left. So again, we're dealing with issues of judgment. They're somewhat arbitrary, but there's a definite continuum, and there can be a framework developed to address these issues. So moving on. The next issue is when we look at planning and we look at the intersection of those property owners and their desire to influence the character of the community, there is some right or interest of property owners to determine what their community looks like. Obviously, there are limits. You don't want a property owner to do whatever they want and to be able to force other people to conform to whatever their worldview is, whether it's prohibiting all development and living in a naturalistic fantasy land where the rural areas never change, or forcing extreme densities in urban areas. And again, this is an interest that has to be articulated and balanced. And SB 146 makes no attempt to consider that. It simply disregards it and holds one form of property rights as being steadfast against all of these other interests. So the self-direction has to be considered. And how do we balance the self-direction against the interest of property owners? Again, it's likely a balancing act rather than elevating a property right to have extreme dominance over the interests of the community to determine its trajectory. So when we look at the canon of property law, the Supreme Court initially recognized this. So the very famous case that any law student has reviewed is the Village of Euclid, which is in Ohio, versus Ambler Realty. And the case dealt with the installation of a gas station in a residential area in a relatively newly developed residential area in Euclid, Ohio. And the gas station owner sued. And what the court said was, it is within the jurisdiction of the Supreme, or within the jurisdiction of the government, to dictate some reasonable restrictions on the use of property. So a couple of points about the canon of zoning as well as planning related law up to recently. It is important to keep in mind that zoning arose out of the interest of property owners in the early 20th century to keep some amount of consistency and congruence in use in newly built areas. And the reason for doing this was, if you could build, for example, a junkyard in a residential neighborhood, there likely would be inevitable conflicts. So the homeowners would be annoyed with, the car crusher. The person running the junkyard would be annoyed that the homeowners are annoyed. And even though they could theoretically write it into private covenants, it was left, especially with regard to government planning, to the elected officials to make a decision that, all right, this area is going to be built up. Let's allocate it for residential uses or for commercial uses. It was by no means originally designed as some type of top-down or authoritarian exercise of government policy. So that is one feature of zoning which must be considered. The other feature to consider of zoning, especially in incorporated areas, is most of them offer some allowance for variances. And the variances can be removed from the administrative proceedings in the communities to state court to litigate disputes relating to whether or not somebody can put in multifamily housing in single family neighborhoods or have a certain use. So again, I think we should take a relatively realistic view of zoning and understand there is a need for consistency. And also historically, there has been some process for variances or appeals. So the economic and social challenges of SB 146. And this isn't explicit in terms of legal analysis of the bill. However, it is important to understand in terms of appreciating what theoretically SB 146 can do, where it comes from, and also the issues that likely need to be addressed to make SB 146 successful. So in terms of social and economic impact, it's responding to obviously various perceptions of the balance of property owners' interest against the balance of the state. However, more broadly, when we look at a lot of the agendas behind SB 146 and the rhetoric that has been promoted in recent years relating to densification, pushing multifamily housing, and also more longer term conversations relating to land use policy, environmentalism, and conservation, what we find is that there are some very distinct challenges of SB 146. So one of the bigger problems that is readily apparent with SB 146 is that if you give property rights unilateral protection by making them strict scrutiny and making it difficult for a community or a government to balance those interests against other interests, you theoretically open up the door for real estate speculators to come in and attempt to squeeze every last bit of profit out of a parcel or a building that they can buy. Now, it's obviously something that is a necessary part of our economy to have investment in real estate, in home construction, in commercial real estate development. However, the problem that SB 146 creates is that you have opportunities for sometimes deleterious development to come to communities. So for example, if you have a older single family neighborhood that, let's say, working class people live in, the houses are modest, it's been there forever, people like the neighborhood, it might not be the ritziest place, but people have a little bit of space, they know their neighbors. SB 146 allows a real estate speculator to come in, buy one house, litigate to remove all of the zoning, and then go in and build a commercial building or a very large apartment building, which would then create a cascading effect, which would result in the entire neighborhood being destroyed. So this is obviously a challenge. And the question that has to be asked is this the best type of policy for land use? Should you prioritize this type of economic efficiency, in quotation marks, against the interests of people in living how they see fit, in, yes, protecting their economic interests, but also balancing that against other things? And to some extent, we have already seen this with a lot of this push for density. So the statistical data on people's housing preferences is incredibly clear. 80% of Americans, regardless of whether or not they want to, or whether or not they say outwardly or not, want to live in single family homes with a little bit of space. To assume that you are going to fix a housing problem by going in and bulldozing neighborhoods and replacing it with 10-story mid-rises that have no space, no parking space, and so forth, is probably a misjudgment, and again, should be considered. Also, in terms of the practicality of forcing density. So, for example, another feature of this push for density is removing building standards that were intended to protect quality of life, but also other infrastructure needs, namely things like setbacks and parking requirements. Now, to density advocates, these are horrible things, but practically, again, when we look at how our economy works, how it is structured, how our communities are structured, a little bit of space is not a bad thing. Ensuring that people have a place to park is not a bad thing. If you remove these standards because they can't meet the strict scrutiny standard, you are creating a huge problem, because what will happen is that people will be forced into the dense multifamily housing. They will still drive their cars. Congestion will get worse. Parking will become a nightmare, and everyone will be worse off for it. So these are considerations. Another consideration here, and this is more of a commentary not on the economic motivations of real estate speculators, but on the ideology and motivation of density advocates, is that there is a subset of the planning community that views density as being unambiguously good. So the more dense the housing, the more people that are forced into public transit, so forth, the better a community is. Well, this is motivated by a ideology that is very limited in terms of its grasp of reality. It is also very limited, again, relative to what most people consider to be desirable. Now, certainly there are communities that can be dense. There are obviously people that want to live in dense communities, but to assume that you are going to remake society and force everyone into essentially what is the 19th century ghetto is a little presumptuous. So the issue here is that even though SB 146 is something that density advocates would consider to be desirable because it creates the opportunity to suck people into density, it only views density as being the only viable option of development for people, and this clearly is not the case. I would encourage you to look at any satellite map of Europe or even Japan. What you will find is that even in, for example, France, you have dense urban areas, yes, but you also have relatively sprawling suburban areas. Additionally, from this perspective of urban planners and density advocates, it doesn't really acknowledge the limits of density. So, for example, if you take that instance of the working class single family neighborhood and you abolish the zoning and the speculators move in and build 6-story apartment buildings, who's going to pay for the infrastructure to deal with the additional people? Likely the infrastructure cost of taking a city block and changing it from 50 by 100 foot city lots to 6-story apartment buildings with 50 units each. The cost of updating that infrastructure is likely greater than the value of any housing added. Additionally, and this is more of a value-based statement, these assumptions are somewhat elitist. And it's interesting when you look at this issue. On one hand, you have a radical free market ideology that assumes that one form of right should dominate and that individuals should tolerate the radical expression of one form of right, property rights. But on another side, with the density advocates, you have a view that says that these advocates, urban planners, also environmentalist groups, should be able to dictate how everyone else lives, regardless of whether or not people want to live in that type of environment. It seeks no balance. It is not egalitarian. And again, it's very elitist, and that should be contemplated. Finally, another feature for the density ideology that I've heard frequently is the idea that by allowing these types of policies to promote density, that it will prevent sprawl. The issue with sprawl is it's somewhat of an arbitrary concept in that if you look at arguments surrounding promoting density, there's never enough density. And that an area, for example, of dense single family homes in an old neighborhood, which by most metrics is relatively dense, is not dense enough. And that we can resolve all of our housing problems by forcing people into greater and greater densities, and that cities will not need to expand. Again, when you look at actual development patterns, you look at what people prefer, this clearly contradicts one, historical precedent, but also preference. Additionally, and this again gets into this issue of people's preference for housing, but also broad concepts of community design, by over focusing on density rather than acknowledging that you're going to have some cities that grow and spread out, you're going to have some suburban and rural development, you're neglecting creating communities, especially in rural and suburban areas, that, let's say, have some conservation space, that are more sustainable, that deal with infrastructure issues in a clear and logical way. And rather than being derisive and saying that all urban expansion is evil, paradise is going to get paved over, we have to hate, houses with big yards or rural houses or people's hobby farms, there needs to be some dialogue about, all right, some people want to live this way. How do we accommodate them? How do we preserve certain natural spaces? How do we mitigate environmental impact? How do we make infrastructure rational? And again, this ideology never engages in that conversation. It simply assumes people will be forced into density. So some solutions. One can never really state a problem without stating solutions. So I've gone through the critiques of 146. How do we fix it to make it work? All told, I do think the idea is a good idea. The big issue here with one, land use, but also a variety of other regulations, is that rational basis needs to be reformed. Anyone with a background in the policy sciences or social sciences knows that no policy will be considered valid unless there is a cause and effect relationship. So you give kids school lunches, they're healthier, they grow up to be more cognitively functional and better citizens. You house homeless people, they stop using drugs. You reform, for example, lengthy prison sentences, costs for prisons go down, and so forth. The idea that you can just create stupid policies and that the law should tolerate it is obviously a highly flawed issue. So the best way to reform rational basis is to have an economic standard that more accurately addresses the balance of interests between individuals and the community. So this does not rephrase economic policy as being strict scrutiny. It simply says that we have to look on a case-by-case basis what the cost and benefit to the community is, what the cost and benefit to the individual is, and then proceed accordingly. A balancing test where the cost to the regulated individual is weighed against the state. That's where rational basis should go. Procedures also, both at an administrative level as well as a judicial level, where individuals can demonstrate less restrictive alternatives. So, for example, if a community that is very urban, and this tends to happen in urban communities, decides we don't want to see any more development in the rural areas because this is our playground, and they pass some regulation that says that you have to have a 500-acre lot, a person who wants to subdivide that land can come in and demonstrate, all right, there's no rational reason to mandate 500-acre lots. They can't make the subdivision 20th of an acre lots. They might have to make it 5 or 10-acre lots with green space, but they can demonstrate that there are less restrictive alternatives. So this is a way of fixing this issue. And one, again, it applies to land use, but also a variety of other things. We see this with economic regulation. We see this with environmental regulation and so forth. The next thing to fix 146 is limit the scope. Limit SB 146 to unincorporated rural areas. So areas that, let's say, do not get city planning or even city services. There's enough flexibility in those areas where an appeals process would make sense. Also, from a political perspective, when you have communities that are dominated by the urban areas, this will give more right and value to the property rights of rural property owners who are generally outnumbered, politically speaking, to be able to use their property as they see fit. Exclude citizen-initiated zoning. Citizen-initiated zoning is a private contract. HOAs, Part 1 zoning, is something that people choose to be part of. If you move into an area, you might not like the rules, but you move there. There's no interest of the state in regulating that. There may be an interest in, for example, excluding the amount of fines or possibility of foreclosure for those fines that HOAs sometimes apply to individuals, which has become an issue with them. But it's not in the interest of the state to meddle again with a private contract amongst individuals. If there is some contemplation of applying SB 146 to urban areas, do not have it apply to things that touch and concern the land, such as the nature of buildings, lot sizes, or building use. However, if there are specific design or aesthetic standards, that may be something that is worth considering. Also, use standards related to short-term rentals are things that might be worth considering. But again, urban areas are mostly dictated by planning and government policy, and the balance there is very different than rural areas. Short-term rentals. There is a concern about the rights of property owners to operate short-term rentals. Arguably, even though this is somewhat related to land use, it is ultimately an economic regulation. It may be useful to consider having regulation that is specifically directed at short-term rentals and how they can be regulated by jurisdictions as something that is separate from broader land use issues. So the conclusion, again, SB 146 is a laudable attempt at articulating a needed balance between property rights and the ability of the government to regulate those rights. Again, rational basis does need reform. We need a balancing test within rational basis. We need a process of appeals administratively and judicially. This would be a major step forward. Additionally, this standard should be considered for other regulations. The interests of community members, especially in urban areas, does have to be contemplated against the interests of one property owner to change a community. A final point to consider that may enhance your understanding of this is there is an essay I wrote dealing with this specific issue. It's called Contiguous Rights. It is included as an appendix in a brief I wrote for the Montanans against irresponsible densification case. That is DV 16, 2023, 1248. And contiguous rights articulates how the court, but also regulatory bodies, can consider this interest of a property owner as a variable interest or property right in maintaining the community in a certain way and help to resolve some of these conflicts. So finally, if you have any questions, comments, or death threats, good or bad, I am more than happy to hear them. I am more than happy to engage in constructive conversation about how to deal with this, as well as other important policy issues. And I can be reached at businesslawpolicyanalysis@gmail.com. Thank you very much.